Okay. Um, Good day, dear students. So we are now on our week 5 of the study of legal philosophy. So for this week, we will be discussing about the nature of law. Okay. So in the book Legal Philosophy for Filipinos, authored by Tabucanon, he discussed there the nature of law. First, he said that law is considered merely as a set of rules, and another, it is regarded as a process. So he said that the common misconception is that the laws are just a set of rules that when dispute arises, all a judge does is to find the right rule and apply it mechanically, even ruthlessly, just how the formalists would regard the law. Here, the root cause or the deeper factors of why there are violations are not being considered, and the impact of such violation to the offender and the offended party. While it can easily clear court's dockets, mabilis lang matapos yung kaso kasi titingnan lang ng judge kung may violation ba sa set of rules or wala. Then he can formulate the decision. But it is kind of dismissive of the other aspects of human experience. In fact, a French satirist, Anatole France, commented that the law in its majestic equality forbids the rich as well as the poor to sleep under the bridges, to beg in the streets, and to steal bread. What does this mean? Who are actually being punished by such law? Well, he said that only the poor. So parang lumalabas, ginawa lang yung batas para sa mahihirap. Why? Because the rich will never sleep under the bridge, nor beg in the streets, nor steal bread, di ba? So ironically, this is the effect of that provision in the Constitution and perhaps almost all constitution in the different countries on equal protection of laws. Okay, so okay. Another nature of law that the author Tabucanon discussed is law being a process. Laws are not just statutes per se, but the whole gamut of life experiences of lawmakers, law enforcers, lawbreakers or followers, as well as lawyers, judges, and legal theorists. He said that a legal issue may be approached from many angles. First, it can be approached historically, whether in second, psychological, third, economic, and fourth, sociological. Ang lumalabas din minsan yung mga deep-seated values innate sa Filipino culture tulad ng hiya, utang na loob, pakikipagkapwa, paggalang, delikadesa, and gaba. So for those who are not Visayan speakers, gaba is like saying, Miris, yan ang napala mo kasi masama ang ugali mo. It's like bad karma. Okay? So, law within religious dogma and tradition has played a significant role throughout history, shaping both secular and spiritual societies. No? Some of the most prominent examples include ancient legal codes like the Code of Hammurabi, religious reformers like John Calvin, and institutions such as the Inquisition. Now, the Code of Hammurabi, one of the earliest written legal codes, dates back to around 1754 before Christian era in ancient Babylon. It consisted of 282 laws and was carved onto stone pillars for public display. While not strictly religious, Hammurabi claimed that these laws were given to him by the gods, which meant that breaking the law was seen not only as a civil crime but also as a sin against divine order. So the code reflects a blend of civil and religious authority, where law was seen as divinely sanctioned. Many of its provisions were based on the principle of lex talionis, or the law of retaliation, famously summed up as an eye for an eye, a tooth for a tooth. So this law emphasized justice and social order within the framework of divine will and was meant to ensure fairness and balance in society. So some examples of laws in the Code of Hammurabi are given in the book, no, in the book of Tabukanon, such as those enumerated in page 28. So for example, if a man has incurred a debt and a storm has flooded his field or carried away the crop, or the corn has not grown because of drought in that year, he shall not pay his creditor. Further, he shall postdate his bond and shall not pay interest for that year. And also another example, an interesting example is if a son has struck his father, his hands shall be cut off. Okay, so um, another prominent example of laws within religious dogma is the Calvinist law of John Calvin. So John Calvin is a leader of the Protestant Reformation in the 16th century, no? Who played a pivotal role in shaping the relationship between law and religious doctrine. So Calvin's teachings on predestination and the sovereignty of God heavily influenced his ideas about and governance and law. So in Geneva, where Calvin established a theocratic government, civil law was deeply intertwined with religious principles. Calvin believed that secular rulers had a divine mandate to enforce God's law, ensuring that both church and state work together to maintain a godly society. So Calvin's Geneva became an example of religious law being used to regulate all aspects of life, from moral conduct to worship practices. So the citizens of the state were called upon in groups of 10 to swear to a confession of faith in the form of 21 articles of belief drawn by John Calvin himself. So in this system, law was understood as the divine will, as the divine will as understood by Calvin himself or by the legislator. So the Constitution and laws of Geneva were recodified in the light of this belief. Civil authorities were tasked with enforcing laws rooted in biblical teachings and punishment for sins like blasphemy, heresy, or moral transgressions could be severe, reflecting Calvin's belief in a society governed by strictly religious discipline. Punishment for non-acceptance of basic doctrines was death at the stake, which happened to the Spanish theologian Michael Servetus. Okay, so another prominent example is the Inquisition. No? The Inquisition was a series of institutions within the Catholic Church established to combat heresy and enforce religious orthodoxy. So it started in the 12th century and became particularly notorious during the Spanish Inquisition in the late 15th century. So the Inquisition's primary goal was to identify, try, and punish those deemed heretics, those people whose beliefs were seen as diverging from the teachings of the church. The Inquisition class blurred the line between secular and religious law as it operated under the authority of both the church and the state. Religious officials would try cases of suspected heresy, but punishment, often involving torture or execution, was carried out by the civil authorities. The sentence was pronounced in a religious ceremony called the auto da fe, or act of faith, where a procession, solemn mass, and sermon preceded the sentencing of the heretics before they were handed to the secular authorities for punishment. The enforcement of religious law through the Inquisition demonstrated how legal systems could be used to enforce dogma and control religious dissent. It was active in France, in Italy, in Spain, and the Holy Roman Empire, and then was extended to the Americas. So, across these examples, several common themes emerge. For example, divine authority. So, religious law often claims divine origin, making it inflexible and absolute in the eyes of its followers. These laws are intended to preserve not just the civil order, but also moral and spiritual purity. Religious legal systems frequently involve harsh punishments, reflecting a belief in strict justice as dictated by divine will. In many religious traditions, law is not separate from religion, but it is actually seen as an extension of it, with civil authorities acting to uphold divine law. Hence, there is an intertwining of church and the state. No? This intersection of law and religious tradition has influenced the development of modern legal system, even as a secularism even as secularism has increasingly separated religious authority from governance in many parts of the world. Now, punta tayo sa Jewish law, no? The Jewish law or the halakha. It plays a crucial role in the intersection of law and religion, serving as both a legal system and religious way of life. Now, originating from Torah and later rabbinical interpretations, Jewish law encompasses all aspects of human conduct, from religious rituals to ethical behavior, civil justice, and interpersonal relationships. Understanding this Jewish law in the broader concept of law and religion, as well as its relation to human rights, provides insight into how legal systems can be deeply rooted in spiritual traditions. Okay. Now, Jewish law and religion. So in Judaism, halakha, or literally the way or the path. This is a collective body of religious laws derived from the Torah, the Talmud, and centuries of rabbinical interpretation. Halakha is not just a religious framework, but also a legal system that governs uh, daily life. Okay, so there are key sources of halakha. No? First is the Torah, or the written law, believed to be divinely given to Moses, which includes the commandments, the 10 commandments that form the foundation of the Jewish law. Torah is the first 5 books of the Hebrew Bible. Another source is the Talmud, or the oral law, composed of the Mishnah, or the codified oral traditions, and the Gemara, or the commentary and discussion. So it serves as a vast source of interpretation of how the Torah's commandments should be applied. Okay. So the rabbinical responsa and codes, that's another source class. So over time, the rabbis issued responsa, or the answers to legal questions, and wrote legal codes such as itong Maimonides Mishneh Torah, and so hindi ko alam kung paano to sabihin, and the Shulchan Aruch, further codifying Jewish law. Anyway, this is just an appreciation of the Jewish law class. Okay, the details aren't, we're not very concerned about the nitty-gritty. In Jewish thought, the law and religion are inseparable. No? Observing Jewish law is an expression of one's covenant with God, and law is viewed as a divine guide for living a moral and ethical life. Halakha regulates everything from dietary laws, or what they call the kashrut, to marriage, inheritance, contracts, and criminal law. So it also emphasizes the importance of justice, fairness, and human dignity, reflecting both the legal and spiritual dimensions of Jewish life. So as for the relationship between secular law and halakha, for observant Jews, halakha exists alongside secular law. Historically, Jewish communities in the diaspora maintain their own legal systems to resolve internal disputes according to Jewish law. Today, observant Jews follow secular law in the countries they reside in. All right? So, while also adhering to halakha in matters of religious practice. So, in some areas of Israel, the rabbinical or the rabbinical courts still have jurisdiction over family law, um, like marriage and divorce. Now, as for human rights in Jewish law, you know, the Jewish law provides an interesting perspective on human rights, as it emphasizes both the rights and responsibilities of individuals, while the modern concept of human rights, as articulated in documents like the Universal Declaration of Human Rights, which emerged much later. Many principles of human dignity, justice, and compassion are deeply embedded in Jewish tradition. So, examples of the key principles related to human rights in Jewish law are the following. The concept, for example, the concept of human dignity and equality. So, one of the fundamental ideas in Jewish law is that all humans are created in the image of God, no? So this concept is a cornerstone of the belief in human dignity and equality. It underscores the inherent worth of every person regardless of social or economic status. And also protection of life and property. So the Jewish law places great emphasis on the sanctity of life and the protection of personal property. For example, sa Ten Commandments, diba, there is one commandment which says, "Thou shalt not murder." Okay? It is seen as a divine mandate to safeguard human life. Similarly, there are detailed rules about theft, damage to property, and financial fairness, promoting the idea that each individuals' material and physical well-being must be respected. Now, they also have this concept of justice and fair treatment. So the Torah repeatedly commands the Jewish people to establish a just legal system. Now, yung sa Deuteronomy class, o if you have read the Bible, Deuteronomy 16:20, it states that um, chapter 16 verse 20 states that justice shall you pursue. So kasi 'di ba yung first five books na that is uh the that forms part of the Jewish law. So the Jewish courts are required to ensure fair trials, protect the innocent, and punish the guilty. Justice is seen as divine value, and Jewish law insists on due process, fairness, and impartiality. So in conclusion, um, in Jewish law, the connection between law and religion is deeply intertwined. Halakha serves as both a spiritual guide and a legal framework, promoting justice, dignity, and fairness while emphasizing religious obligations. Regarding human rights, Jewish law upholds many principles that align with modern human rights, such as sanctity of life, equality, and the protection of the vulnerable. However, Jewish law is distinct in its focus on duties and responsibilities as much as rights, no? Making it a unique system where morality and law work in tandem to create a just and ethical society. Now, let's proceed with the Islamic law and religion, no? That's the Sharia, Islamic law. Islamic law or the Sharia is rooted in the teachings of the Quran or the Holy Book of Islam and the Hadith. Now, the Hadith is the combination or the collection of the sayings and practices of the Prophet Muhammad. It is not just a set of legal rules, but a comprehensive ethical guide for Muslims, governing both the public and private aspects of life. So, what are the key sources of Sharia? First, of course, is the Quran. The Quran is the primary source of Islamic law and contains direct commandments from God regarding worship, morality, social relations, and legal matters. So Muslims believe the Quran or believe that the Quran is the literal word of God revealed to the Prophet Muhammad. Another source of the Islamic law is the Hadith, which records the sayings and actions of the Prophet Muhammad, no? This Hadith supplements the Quran by providing guidance on issues that are not or that were not explicitly covered in the Quran. So the Hadith, this is critical actually in shaping the Islamic legal rulings. They also have this ijma or the consensus and the qiyas or the analogical reasoning. The Islamic scholars or jurists also rely on this, no, the ijma, the consensus of the learned, and the qiyas or the analogical reasoning to develop legal rulings on issues not directly addressed in the Quran or Hadith. So, as a legal system and a moral system, actually, Sharia governs aspect of Muslims' life. So, from personal matters like marriage, divorce, and inheritance, to criminal justice and financial transactions. In many Islamic countries, Sharia plays a formal role in the legal system, particularly in areas of family law and personal status. However, the interpretations of Sharia can vary significantly across different regions, no, and cultures. So, it means yung interpretation ng Sharia law, iba in Saudi Arabia, iba rin in Dubai, iba rin in the Philippines, in Malaysia or Indonesia. So may pagkakaiba no sa weight ng interpretation. Yung ibang countries, Muslim countries, talagang very strict by the letter, no? Dito naman sa Philippines, I am not really sure, but parang hindi siya kasing stricto, no, as compared to the Arab countries. Well, anyway, Muslims are expected to live their lives in accordance with Sharia principles, which include not only legal obligations but also ethical guidelines on charity, honesty, and justice. So, this integration of law and morality reflects the belief that the ultimate purpose of Sharia is to help Muslims live in harmony with God's will. In fact, class, may mga kakilala akong mga Muslims din, no, practicing the Islamic religion, pero magkaiba rin sila ng practices, magkaiba rin sila ng ng way of life. So, siguro ganun. Parang Catholics din, may iba na very strict talaga sila, mag-adhere doon sa practices or sa mga established rules. Yung iba naman, how do you call that? Liberated, right? Liberated. So, well, I have a friend. She's a lawyer, and she does not notarize documents involving yung mga utang, yung mga promissory notes. So, ayaw niya yan. Kahit na millions yung involved and, well, yung um, pwede siyang maka-earn ng considerable amount from that transaction, ayaw niyang magnotaryo ng gano'n. Sabi niya sa akin, parang it's against her practice. Meron din naman akong isa pang kakilalang lawyer na okay lang din naman sa kanya mag notaryo ng mga ganon. Okay, way back in college, meron din akong roommate na Muslim din, and yet she's very fond of yung concerts, mga medyo medyo gano'n na nga. Pero meron din akong isang friend na Muslim din in that same dormitory na hindi rin siya nakikinig ng mga music ng Backstreet Boys or mga ganon-ganon. So during that was my time, okay? So magkakaiba rin. Anyway, um as I've mentioned earlier, Muslims are expected to live their lives in accordance with Sharia principles, which include not only legal obligations but also ethical guidelines on charity, on honesty and justice. This integration of law and morality reflects the belief that the ultimate purpose of Sharia is to help Muslims live in harmony with God's will. Now, um, for going to human rights principles in Sharia class. So there is a relationship between human rights and Islamic law. So such relationship is a subject of ongoing debate and interpretation. While Islamic law emphasizes many principles that align with modern human rights such as justice, compassion, and protection of life, It also contains elements that some critics argue are in tension with contemporary human rights standards. So, what are the key human rights principles in Sharia? So, ano ba to? They also have this concept of human dignity and equality. Like in many religious traditions, Islamic law um, holds that humans are created by God and are therefore entitled to dignity and respect. So, naka-emphasize it, or it's being emphasized in the Quran, no? Indeed, the most noble of you in the sight of Allah is the most righteous of you. While the notion of equality is rooted in Islam, how it applies to specific groups such as women and non-Muslims can vary, no, based on interpretation. Now, they also have this concept of right to life and protection. The sanctity of life is fundamental principle in Islamic law. So the Quran states that taking a single innocent life is like killing all of humanity, while also or while saving a life is like saving all of humanity. So Sharia provides strict penalties for murder, but it also allows, no, for concepts like kisas, or the retributive justice, where victims' families can demand punishment for the perpetrator or offer forgiveness. Right. And their concept of justice and fair treatment class, this is central in Islam. One of the names of God in Islam is Al-Adil, or the just, and Muslims are commanded to uphold justice in all matters. The Quran commands Muslims to stand firm for justice, even if it is against themselves or their loved ones. Islamic law provides guidelines for fair trials, evidence, and punishment. No, so the judges are expected to be impartial and ensure due process. So pagdating naman sa economic and social rights, the Islamic law includes provisions for protecting the rights of the poor and the vulnerable. The Quran mandates zakat, if you're familiar with that, or the charitable giving, which is one of the five pillars of Islam. So Muslims are obligated to give a portion of their wealth to help the poor, the widows, the orphans, and those in need. This reflects the Quranic principle of social justice and the importance of community welfare. Now, the rights of women and family law. So medyo ano ito class, no? Sensitive ito pagdating sa Islamic law. Kasi women's rights in Islamic law are a topic of considerable debate. The Quran grants women certain rights, such as the right to own property, the right to inherit, and the right to seek divorce under specific conditions. However, traditional interpretations of Sharia often limit women's roles in society, particularly in matters of family law, inheritance, and testimony. For example, in many interpretations, a woman's inheritance is half that of a man's, and her testimony in court may carry less weight. Islamic law, or Sharia, is deeply intertwined with the Islamic religion, serving both as a legal system and a moral code. So it governs all aspects of life for Muslims, no? Reflecting the belief that divine law is superior to human law. So regarding human rights, the Islamic law actually upholds key principles of justice, dignity, and social welfare, but tension exists in areas such as gender equality, freedom of religion, and freedom of expression. There have been efforts, class, to reconcile Islamic law with human rights principles. For example, the Cairo Declaration of Human Rights in Islam in 1990. It issued, it was issued by the Organization of Islamic Cooperation. No, it is an attempt to articulate human rights from an Islamic perspective. It emphasizes many of the same rights found in international human rights documents, but frames them within the context of Sharia. Okay. Progressive Muslim scholars and reformers have also argued that Islamic law can be reinterpreted to align more closely with contemporary human rights standards. They emphasize that many discriminatory practices associated with Sharia are not mandated by the Quran itself but are products of later legal interpretations and cultural customs. However, ongoing interpretations of Sharia and efforts toward reform show the Islamic law has the potential to evolve in ways that harmonize with modern human rights standards. So that basically is um, are the concepts now of human rights principles in Sharia. You can find that in the book of Legal Philosophy for Filipinos by Phil Marvel Tabucanon, and some of the concepts that I discussed earlier can also be found in the book Philosophia by Bernardo. Now, let's proceed no, sa canon law. What is this canon law? Okay? Canon law and religion. Well, canon law is the legal framework used by the Catholic Church to govern its members and internal matters. Okay? Its purpose is to maintain order, protect the rights of individuals, and ensure that the church mission and teachings are upheld. So, canon law is deeply intertwined, just like also in the Sharia and in the Jewish law. No? Well, the canon law is deeply intertwined with Catholic theology, and many of its provisions are based on the church interpretation of scripture and sacred tradition. Now, what are the key sources of canon law? We have the Code of Canon Law, the primary document governing the church today. So that is the 1983 Code of Canon Law for the Latin or Western Church, and the 1990 Code of Canons of the Eastern Churches for Eastern Catholics. So these codes regulate the structure of the church and the rights and duties of clergy and laity, also the sacraments and other ecclesiastical matters. Canon law is grounded in Christian doctrine, particularly teachings about the authority of the Pope and bishops, the sacraments, the moral teachings of the church. It is unique in that it does not just focus on legalities but also on the spiritual well-being of Catholics. Um, it covers matters such as church administration, discipline of the clergy, the conduct of religious ceremonies, and the sacraments. For example, it governs marriage in the church, outlining the requirements for valid and licit marriages according to Catholic teaching. Although canon law is primarily concerned with the church spiritual mission, it also affects the everyday lives of Catholics. providing rules on worship, moral behavior, and governance. Okay, so it establishes the church legal structure such as the hierarchy of authority, no? Yung hierarchy of authority in the Catholic Church, Pope, bishops, priests, and how decisions are made within the church. Now, how about the interconnection or the relationship of human rights in canon law? Okay, canon law, while primarily religious in nature, it actually includes provisions that relate to human rights, especially through the lens of Catholic theology. Catholic teachings emphasizes the dignity of human person, the justice and the common good principles which are reflected in canon law. So there are also key human rights principles in canon law. For example, again, no? Dignity of the human person, nandiyan rin yan sa Jewish law, nandiyan din sa Islamic law. Because the Catholic Church believes that the dignity of every person is central, no, to canon law. So it is actually central to Catholic social teaching. This principle is rooted in the belief that all humans are made in the image of God, and therefore have intrinsic worth. So, canon law reflects this in its provisions that protect individuals. Kaya, walang pangit, walang hindi maganda kasi every one of us, every human being is created, no, in the image of God. Now, canon law reflects this in its provisions that protect individuals, especially regarding their spiritual well-being and moral integrity. So, how about the rights of the faithful? Pag sinabing right, yung faithful, yung those who practice the Catholic teachings, no? Canon law provides specific rights to all members of the Church as outlined in Canons 208 to 223 of the 1983 Code. So these include the right to receive the sacraments, the right to a Christian education, the right to form associations, and the right to express opinions within the Church on matters of faith and morals. This demonstrates that canon law recognizes the spiritual and social rights of the faithful within the context of church life. Now, the canon law also has this concept of fair trial. So, it includes provisions for due process and justice, especially in ecclesiastical trials. For example, those dealing with annulments or clerical discipline, di ba? So, minsan naririnig nyo yan sa mga Katoliko, di ba? Annulled na kami sa simbahan. And in fact, yung annulment sa simbahan class, nagkakaroon din siya ng impact or effect, no, kapag nagpa-annul kayo sa courts. So, well, hindi naman siya necessarily na requirement, but it can have an effect on the petition. Now, individuals have the right to a fair trial and defense, and the church ensures that tribunals follow proper legal procedures. This aligns with the broader human rights principles regarding justice and fairness. So, also, nandyan rin yung protection of marriage and family because canon law places a strong emphasis on the sanctity of marriage and the family, and it seeks to protect these institutions. The rights of spouses, children, and families are protected under canon law, especially in matters like marriage validity and parental responsibilities. The church teachings in marriage, although sometimes different from secular law. For example, syempre, yung secular law, yung enacted laws, no? They emphasize the dignity of family life and the importance of marital fidelity. So, pagdating naman sa social justice and charity, the Catholic teaching as reflected in canon law emphasizes the importance of social justice and the duty of charity. This includes the responsibility of the church and its members to care for the poor, oppressed, and vulnerable. Canon law mandates that church institutions such as schools, hospitals, and charities work toward the common good and uphold the dignity of all people. But of course, there are tensions between canon law and modern human rights. While while canon law emphasizes human dignity and justice, there are areas where it may appear to be in tension with modern interpretations of human rights, especially in areas such as gender equality, freedom of religion, and marriage laws. So, for example, sa gender equality, the Catholic Church prohibits women, 'di ba, from becoming priests or from serving as priests. So it's a point of tension kasi may mga babae gustong maging pari or mga Catholics gustong maging pari. Now in other religion, may mga may mga women na pastors, 'di ba? So, canon law reflects the church beliefs in the distinct roles of men and women within the church, with some view as discriminatory, or which some view as discriminatory. However, the church maintains that these roles are based on theological principles and not on human inequality. Now, pagdating naman sa freedom of religion, while canon law respects religious freedom, particularly in the context of religions or of other religions, it also emphasizes the truth of the Catholic faith. So this sometimes leads to criticism that the church stance on religious freedom can appear exclusive or intolerant of other belief systems, no? Okay. So, pagdating sa marriage and family life or family law, canon law stands on issues such as divorce, contraception, and same-sex marriage differ significantly from many secular laws. For example, the Catholic Church does not recognize divorce, right? Instead, it offers annulments under certain conditions. So the Philippines being generally a Catholic country, kaya nahihirapan talaga ngayon ma-push through yung ating divorce law. Okay? May annulment tayo, but you know very well how difficult it is, no, to establish the grounds for annulment. Maliban na lang yung palaging go-to provision, no, on psychological incapacity. So critics argue that this stance can infringe on individual freedom, though the church holds that its teachings reflect God's plan for marriage and family life. Now, okay. So I have already discussed the tension between canon law and modern human rights, right? Now, um, in recent years, the Catholic Church, no, so well, we have lots of modern human rights movements nowadays, no? Because in recent years, the Catholic Church has engaged in dialogue with international human rights movements. Documents like the Universal Declaration of Human Rights are compatible with many Catholic um, teachings, especially on issues like the dignity of the person, social justice, and the protection of life. The Church, through canon law, advocates for human rights in areas such as anti-poverty, um, labor rights, and anti-racism initiatives. However, the church positions on issues like reproductive rights and gender roles remain areas of divergence from modern secular human rights advocacy. Nonetheless, class, the Catholic Church plays an active role in promoting the dignity of the person and social justice on a global scale, working within the framework of both canon law and international human rights principles. All right, so in conclusion, the canon law reflects the Catholic Church belief that law and religion are inseparable as it governs both spiritual and legal aspects of church life. And it emphasizes the dignity and rights of individuals, particularly within the framework of Catholic teaching on justice, fairness, and social responsibility. While canon law aligns with many principles of human rights, such as the right to a fair trial, social justice, and human dignity, there are areas of tension, particularly concerning gender equality and issues related to marriage and family. Nonetheless, canon law continues to evolve as it engages with modern human rights discussions, balancing traditional religious beliefs with contemporary social and ethical challenges. Okay, so that ends our discussion on the nature of law. Thank you for listening.